Okay, are there any further amendments? Yes, Ms. Clarke, you're recognized.
Mr. Chairman, I have an amendment at the desk labeled
You
amend.
are recognized.
Thank you, sir. My amendment is
The clerk will
labeled,
report the amendment. Yeah, go ahead. Yeah, if you can discuss it with the,
yeah, I was going to
yeah,
tell
go
him
ahead.
what amendment
So
it
make
is.
sure that he knows which one you're talking about. Yeah,
Okay, here we go.
okay.
Amend 4312-02-XML, underscore, excuse me.
The clerk will report the amendment.
Amendment to HR 4312, page 2, strike line 12 and all that follows through line 17. Page 25, strike
Without
line
objection, the reading of the amendment is dispensed with, and the gentlelady is recognized for 5
Mr.
minutes.
Chair, I reserve a
for
point of order.
amendment. The gentleman reserves a point of order.
Thank you, Mr. Chairman.
Mr. Chairman, I move to strike the last word to speak on.
You are recognized.
Thank you. As I've said before, I'm deeply troubled by the antitrust exemption this bill would provide the NCAA and other athletic conferences. Let me remind you all that antitrust lawsuits brought by current and former players are the reason athletes have been able to achieve the gains of the last few years. And if history is any guide, the NCAA and other athletic conferences simply cannot be trusted with creating fair guidelines that protect college athletes and their abilities to profit from their own name, image, and likeness. We simply cannot turn to the same entities that created the broken, inequitable system of the past to serve as the stewards of a new system. We are already seeing the folly in this thinking play out with the newly created College Sports Commission as proposed NIL deals are rejected out of hand due to its decision to arbitrarily decide that college athletes cannot accept certain appearance fees, which seems fundamental to monetizing the value of one's name, image, and likeness. And to pair this antitrust exemption with a broad preemption of state law, which would prevent state attorneys general, local law enforcement, and college athletes and their families from bringing causes of action under state law when the NCAA and the conferences make serious mistakes, is the wrong move. When college athletes are sexually assaulted by their coaches or trainers, something we have seen before, they should have a cause of action in state court. When college athletes die on the practice field because of heat stroke, something we have seen before, their families should be able to go to court to seek justice and to help make sure that this doesn't happen to other people. Let's empower college athletes instead of giving the NCAA everything on its wish list without regard to the consequences of doing so. With that, Mr. Chairman, I yield back.
Thank you. The gentleman yields back. Any further discussion on the amendment? Mr. Fryer, you're recognized.
Mr. Chairman, I withdraw my point of order and I move to strike the last word.
You're recognized.
Mr. Chairman, I oppose this amendment because it would allow the current Wild West that college athletics has right now to continue to wreak havoc on our institutions and our student athletes. The antitrust liability in Section 7 is necessary to provide stability and clarity for the athletic ecosystem. If they are constantly facing litigation, their budgets will change, and this will lead to cuts in non-revenue generating sports. This protection is conditional with compliance with the SCORE Act, which allows interstate intercollegiate athletic associations to create and enforce rules that are narrowly tailored to issues including NIL, transfers, and eligibility. The NCAA, conferences, and schools have voiced that they are not asking for a blanket liability shield, but they need room to breathe. They need that oxygen. The SCORE Act allows for this while still providing necessary accountability. Lastly, this bill needs strong preemption because a patchwork of state laws is unsustainable and leads to competitive disadvantages. Without this preemption, athletes in different states will face unequal opportunities, confusing standards and enforcement gaps, undermining both competition and the athletic programs themselves. I urge my colleagues to vote no, and I yield back.
Any further discussion on this side of the amendment? Yeah, Ms. Kasser, you're recognized.
Thank you, Mr. Chairman. I have a few questions because this is a very broad preemption of state laws and then an antitrust exemption. And some outside groups have raised significant concerns that the preemption clause in the current draft not only stop states from enacting or enforcing laws, rules, regulations, requirements, or standards, but it also allows any defendant to get lawsuits dismissed by asserting preemption. So I wonder, counsel, is that the operation of the text of the current SCORE Act? Say, for example, if an athlete wanted to bring a claim for sexual harassment, and state law currently allows them to do that, would the SCORE Act preempt them from being able to bring that kind of suit?
Thank you for the question. Section 10 on page 29 reads that no state or political subdivision of a state may maintain, enforce, prescribe, or continue in effect any law, rule, regulation, requirement, standard, or other provision having the force and effect of law that governs or regulates the compensation, payment, benefits, employment status, or eligibility of a student athlete, including a prospective student athlete, with respect to participation in intercollegiate athletics, including any law, rule, regulation, requirement, standard, or other provision that relates to the right of a student athlete to receive compensation or other payments or benefits directly or indirectly from any institution, associated entity, or individual, conference, or interstate intercollegiate athletic association.
So is there a yes or no answer to my question?
There's more. 10.2 limits or restricts a right provided to an institution, a conference, or an interstate intercollegiate athletic association under this act, and requires a release of or license to use the name, image, and likeness rights of any individual participant or group of participant in an intercollegiate athletic competition.
Thank you, counsel, because I read the text, and that it's complicated. That's why I want to just ask that simple question. And one example is a sexual harassment issue, which there have been many cases like that, unfortunately, across athletics. So would this preemption and the liability shield, would it bar a student athlete from bringing that kind of claim that is currently authorized by state law?
As mentioned in Section 10 preemption section, it's as it relates to the bill.
So is that a yes or a no?
It's as it relates to everything aforementioned, so
All right, so
governing compensation, pay.
What if there's a coach or a staff member sexually harasses a student athlete, and the state law says they can bring it, but the institution then, this has unfortunately happened as well, the institution punishes the athlete because they want to protect the coach, then and that impacts their ability to receive compensation. Would a student athlete be able to bring that kind of case, or does it, under this broad preemption and liability shield, would that suit never even make it, never see the light of day? Be subject to a motion to dismiss?
As mentioned, the preemption section 1, 2, 3, 4, and otherwise related to this act.
And then at the end of the bill, there is kind of a catch-all provision that says, that's very broad, is otherwise related to this act. So that could be very broad as well. So do you see my question, Mr. Chairman, on
Yeah,
this?
and
That this is, we need to be careful with I think there is some interest in having preemption, but if you're also, I'm not interested in taking away the rights of student athletes that are sexually harassed, abused, or if there is another, say there's another cause of action for fraud. The answer that I'm taking away from counsel's answer is yes, that those kind of cases could be barred from
Well, let's,
coming forward.
I'll work with you on that, because obviously that's not the intent.
Okay. Thank you.
Let's,
I've run out of,
between now and the next markup, okay?
thank you. I
I
yield back my
appreciate that
time.
very much. Thank you. All right, any further discussion? Yes, Mr. Soto, you're recognized.
Thank you, Mr. Chairman. We all could agree college sports are fundamental to our American way of life, and I agree, we do need consistent rules of the road for name, image, and likeness in college sports, otherwise known as NIL. And I agree we should have a revenue sharing pool to help out with these many sports. You mentioned that 16 different sports will be protected. In addition, authorizing NIL rights for students is critical. And access to medical coverage, academic support, and scholarship protections, all important. However, exempting student athletes from state and federal labor laws proves fatal when we're looking at the limited liability conditions. Those are also concerning. This bill creates an official statutory monopoly for the NCAA after the Supreme Court struck that down. And while I'm supportive of that general principle, I don't think enough is given in return by way of duties to give this fundamental distinction of being a monopoly. This bill bans student athletes from First Amendment rights to form unions, also guaranteed by the National Labor Relations Act. I constantly hear we should be making government more like the private sector. Well, every major sports league has a players' union. America loves our college sports. We love our college athletes. And so let's ensure that our student athletes, they have basic rights like the right to organize. The ability to negotiate and better liability rules will ensure this bill will be more flexible to the many challenges we foresee today and that we don't foresee in the future, and also make it more likely that this bill becomes bipartisan and lasting. And so I'm deeply concerned today, but I'd like to get to yes, like a lot of us here today are talking about, whether it's the issues that are brought up by many of my colleagues or this one point. And so I'm hoping, Mr. Chairman, we can continue to work on this and maybe get a bipartisan product before we get to the full committee markup. And I yield back.
Is there any further discussion? Yes, Ms. Trahan, you're recognized.
Thank you, Mr. Chair. I move to strike the last word? Yeah, move to strike the last word. Thank you. And I just want to put a little bit of punctuation on what we're giving away and the process by which I would argue we should undertake before doing that. I mean, I have a hard time believing that if we grant the NCAA and powerful conferences the sweeping antitrust exemption that currently exists in the bill, Congress is going to come back and revisit it if they overreach. I mean, once we give this shield to an organization like the NCAA, we won't get that power back. I would suggest that at the very least, we more narrowly tailor this exemption to precisely what's in the House settlement, which is what the association initially asked for, and that we institute a sunset provision. We can make it 10 years to coincide with the expiration of the House settlement. We could make it 9 years to line up with the NCAA's next media rights negotiation. Either way, let's make them prove to us that they deserve this shield. It will be a check on their power and a way for Congress to address issues that arise in college athletics over the next decade. I yield back.
The gentlelady yields back if there's no further Mr. Pallone, you're recognized for 5 minutes.
Strike the last word. I yield now to the gentleman from Florida, Ms. Castor.
Thank you, Mr. Plum, for yielding the time. And I just wanted to say to Rep. Tran, that is a great idea to sunset something that would kind of keep the pressure on the NCAA to do the right thing, that would keep Congress involved, our appropriate oversight authority. And Chairman Bilirakis, was a sunset considered before?
We could always come back and review it next year without putting the sunset clause in there. It's not in there now at this particular time.
Okay, I was curious about that. I think that would be very smart. Also, Mr. Chairman, I wonder also what is contained in the bill that encourages or incentivizes student athletes to actually get their college education? I'm just curious. A lot of folks at home, when they say we're dealing with NIL and student athletes, a lot of people comment to me and say, you know, I'd really hope that that student athletes are not just professional athletes, that they are student athletes and they have the ability to attend school. They're not just focused on sports, but
Well-
they are able to obtain their college degree or
And that's certainly our goal. When you read the bill, there is language in there encouraging our amateur athletes, that's what they are, and that's what we want to keep is the amateur status. But there is language in there incentivizing, encouraging, and helping with studies, with life lessons, what have you. So I believe that there's adequate language there incentivizing these athletes, because after all, that's what they're there for, is
maybe
getting
council
a good
can point me-
education. So if you'd like to, if you can read the bill, I'll be happy to work with you, possibly to strengthen it, but I think it's adequate.
Can the council point, I'm curious, because I read through it, and what can I share with folks back home that ask this question? What is in the SCORE Act that really incentivizes or encourages student athletes and institutions to focus on the education of these students?
Thank you for the question, ma'am. I believe that would be a policy question, but Section 5 has certain requirements applicable to certain institutions, which includes providing comprehensive academic support and career counseling services to student athletes that include life skills development programs with respect to mental health, including alcohol and substance abuse, strength and conditioning, nutrition, name, image, likeness rights, including related legal advice, financial literacy, including taxes, career readiness and counseling, the process for transferring between institutions, sexual violence prevention. Subsection 2 provides medical and health benefits to student athletes.
Thank you, council. So what I'm taking away that you agree that is an important goal, and maybe we can work together to kind of hone in, as we're going to be working with the other committee as well, kind of hone in and see what else we can be doing to encourage that these student athletes have every opportunity to attend class, to get their college education, and to obtain their degree.
That's the goal.
Okay,
That's definitely the goal.
okay, thank you. I yield back.
Yeah, and our side wants to work with you on that as well. But again, amateur athletes, and so you want employment, with all due respect, but then you want the amateur athletes, and the goal is obviously the priorities for them to get a good education. So I'll be happy to work with you on it. Yes, the chairman of the full committee. Is that correct? Oh, I thought you had your hand up. I guess you didn't. All right. No problem. Yeah, you talk with your hands like I do. Anyone else here? All right, let's go ahead and, if there's no further discussion, the vote occurs on the amendment. All those in favor shall signify by saying aye. Aye. All those opposed, nay. Okay, the nays have it, and the amendment is not agreed. Okay, the chair. Okay, the chair requests a roll call vote. The gentlelady requests a recorded vote. The clerk will call the roll.
Mr. Fulcher? No. Mr. Fulcher votes no. Mr. Dunn? Mr. Dunn votes no. Mrs. Kamick? Mr. Obernolte? Mr. Obernolte votes no. Mr. James? Mr. Bentz? Mr. Bentz votes no. Mrs. Houchin? Mrs. Houchin votes no. Mr. Fry? Mr. Fry votes no. Ms. Lee? Mr. Kane? Mr. Kane votes no. Mr. Evans? Mr. Evans votes no. Mr. Goldman? Mr. Goldman votes no. Mr. Guthrie? Mr. Guthrie votes no. Ms. Schakowsky?
Aye.
Ms. Schakowsky votes aye. Ms. Castor? Ms. Castor votes aye. Mr. Soto? Mr. Soto votes aye. Mr. Han? Mr. Han votes aye. Mr. Mullen? Mr. Mullen votes aye. Ms. Clarke? Ms. Clarke votes aye. Mrs. Dingle? Mrs. Dingle votes aye. Mr. Vesey? Ms. Kelly? Ms. Kelly votes aye. Ms. Schreier? Ms. Schreier votes aye. Mr. Pallone? Mr. Pallone votes aye. Mr. Bilirakis? Mr. Bilirakis votes no.
And I believe Ms. Lee, how is Ms. Lee recorded?
Ms. Lee is not recorded. Ms. Lee votes no.
Anyone else on the Democrat side? Anybody on the Republican side? Okay, the amendment is not agreed to. Well, you can you can tell us exactly the yeas and nays, please.
Mr. Chairman, on that vote, there were 10 ayes and 12 noes.
Okay. The amendment is not agreed to.